Good morning, Judge Stevens. I cannot see or hear you. There we go.
Okay, I was surprised that this was on YouTube.
Yes, it is being streamed to YouTube.
Okay, is there some, I didn't see that in the notice, I'm just pointing that out. It
Okay.
doesn't matter. It would be something just nice to know, but it's okay.
It looks like we have a number of attorneys. We only had an invite list that included 4 attorneys for the plaintiff, but we do have significantly more than that. I don't know if you want them all.
There are 4 attorneys who are arguing.
Mm-hmm.
And but they are representatives of a plaintiff class.
Okay,
so the others can come in the waiting room.
Okay, so keep them in the waiting room and just bring in the people that we had on the invite list.
Yes, please, unless they tell me something different when we start.
Okay. I am not seeing that the court reporter is here yet, so I will check and see what's going on with that.
Okay.
And
let me know.
I will be back shortly.
Okay.
Judge Stevens, we now have the court reporter, so I can start bringing in the attorneys when you're ready.
Okay, that is fine. This is consolidated cases 20-00094, 102, 103, 111, 112, 116, 118, 121, 140, 151, 156, known collectively as Krieger et al. Versus Michigan Department of Environment, Great Lakes, and Energy. As counsel come in, they will state their appearances. For those who are watching this, I would make you aware that while there are many very fine lawyers on this case, they have selected a team to present the arguments to the court for both the motion and for the omnibus response. All counsel who are on these cases, of course, have participated fully in the presentation and preparation of the materials to the court and are invited, and most are present in the waiting room, but will not participate in oral argument.
Your Honor.
We'll wait till everybody's here and then we'll accept all appearances. Okay. I believe we're all here at this point. The court reporter, as you know, has the distinct disadvantage of not being in the same room with counsel. If at any point in time that she cannot hear or understand what is being said, she's going to break her muteness and immediately let us know so that the record can be as complete as possible. Counsel, would you please state your appearances for the record, beginning with those persons who are representing the plaintiff group?
Good morning, Your Honor. Melvin Butch Hollowell, one of the plaintiff's liaisons, and I would respectfully request that David Dubin be admitted from the waiting room. He will argue on behalf of the class plaintiffs, and Ben Johnson will argue on behalf of the mass plaintiffs.
All right, I would ask Morgan, if you heard that, if you would admit Mr. Dubin, who will join us shortly. Mr. Johnson.
Good morning, Judge. Ben Johnson on behalf of the mass plaintiffs.
Thank you. And on behalf of the defendants, please.
Good morning, Your Honor. Assistant Attorney General Nathan Gamble on behalf of the Michigan Department of Environment, Great Lakes, and Energy.
Mr. Gamble, you are probably speaking as loudly as you can, but I know that I'm having a little struggle, and I do not want the court reporter to have such as well. So if you could either get closer to your mic or project. Thank you.
Of course. Thank you for letting me know.
Yes,
my name is Nathan Gamble, Assistant Attorney General. I'm appearing on behalf of the Department of Environment, Great Lakes, and Energy, the Michigan Department of Natural Resources, and also the Michigan Department of Attorney General, who's been named.
Thank you.
I didn't hear the end of what you said. I don't know why your audio is kind of very low.
You couldn't hear the last thing I said, Ms. Court Reporter?
No, it sounded like you were a million miles away.
That would be Ms. Roberts. She could not hear you. So try again. I don't know how much closer you need to get. Can we just do a sound check?
Yes. Can you hear me okay right now, or is it still like a million miles away?
Okay, right now. Yes.
Okay. I'll repeat my appearance. Would that be helpful?
Yes.
Okay. My name is Nathan Gamble. I'm an Assistant Attorney General. I'm appearing on behalf of the Michigan Department of Environment, Great Lakes, and Energy, the Michigan Department of Natural Resources, and the Michigan Department of Attorney General.
And the next appearance, please.
Good morning. This is I'm sorry, Your Honor. This is Ted Leopold, also liaison counsel, along with Mr. Hollowell and Mr. Johnson for the plaintiffs. Good morning.
Good morning, Your Honor. My name is Danielle Allison Yoakum. I'm an Assistant Attorney General here this morning on behalf of the Michigan Department of Environment, Great Lakes and Energy, the Michigan Department of Natural Resources, and the Michigan Department of Attorney General.
Who is going to manage the argument on behalf of the move-ats defendants?
That will be me, Your Honor, Nathan Gamble.
Please proceed.
Thank you, Your Honor. These cases are about the failure of the Edenville Dam, but the Edenville Dam was privately designed and privately constructed, and it is privately owned, privately controlled, and privately operated. The plaintiffs are correctly suing that private owner of the dam because of the dam's failure. The state is also suing the owner of that dam. But in these cases, the plaintiffs are also attempting to sue the state regulators for that private dam's failure, but their claim is not supported by law. They do not cite a single case where a court has allowed a takings claim against the government because of the failure of a private dam. They do not discuss in any way the body of case law involving constitutional claims related to dam operations. The Edenville Dam is not the first dam to fail or the first dam to be responsible for flooding. There are plenty of constitutional suits that have been filed over the years related to dams, mainly involving the federal government. But the plaintiffs don't discuss any of that case law. That is because the starting place in that case law is with the government owning, operating, or controlling the dam. That obviously isn't the situation here, so that case law doesn't apply, which is why the plaintiffs don't cite it. Really, that's just one more red flag in these cases, Your Honor, for why these lawsuits never should have been filed to begin with. Really, these cases are just a tort claim. They're a tort claim for property damages. The plaintiffs believe that the state owed them a duty to regulate the Edenville Dam in a particular way, that it violated that duty, and the violation caused them property damage. That's a tort claim. But that's precisely the type of tort claim that the state is and always has been immune to. But no, the plaintiffs say this isn't a tort claim. They say this is a constitutional claim for inverse condemnation. No, it is not. The state did not design the Edenville Dam or construct it. It does not own the Edenville Dam. It does not control it or operate it in any way. And importantly, the state did not breach the Edenville Dam or order that the dam be breached or take any other affirmative action directly aimed at the house of David Krieger, Margaret Sperling, or any other plaintiff. Well, the plaintiffs say, they say the state forced the private owner to raise the level of Wixom Lake in the spring of 2020 higher than it otherwise would have been. No, it did not. Plaintiffs' own exhibits, public court filings, show that accusation to be incorrect. Exhibit 11, Plaintiffs' Exhibit 11, is the petition that Midland and Gladwin counties filed in their circuit courts to maintain the lake levels on Wixom Lake that, quote, had been harmoniously maintained for nearly 100 years. The counties filed that petition, not the state. And they filed it with the help of a professional engineer that they hired that reviewed the dam's history and supported the county's petition. The plaintiffs attach Exhibit 13. That is the report prepared by the county's professional engineer on the lake level of Wixom Lake. And throughout that report, it repeatedly insists that it is recommending that the court simply maintain the lake level that had already been in place for nearly 100 years, and that doing so would not have a detrimental impact on private property. On page 13 of Plaintiffs' Exhibit 13, it says, quote, since the lakes have been established for nearly 100 years and the shoreline around the lakes are highly developed, maintaining the status quo is feasible and prudent and introduces no changes to the established environment. Page 2 of Plaintiffs Exhibit 13 says the recommendation is no change to historically observed water elevations. Page 4 of Plaintiffs Exhibit 13, quote, signs of instability or structural fatigue have not been observed. Page 5 of Plaintiffs Exhibit 13, quote, the lakes and dams already exist and no changes to current FERC regulated water elevations are being proposed. Page 19 of Plaintiffs Exhibit 13, quote, the establishment of state of Michigan normal lake levels that match the FERC normal lake levels licenses would not introduce detrimental impacts to private property. Page 19 in Plaintiffs Exhibit 13, again, it says, quote, the recommendation is no change to historically observed water elevations. Your Honor, these are the plaintiff's exhibits. This is not some secret knowledge. These are public court filings, including a report prepared by the county's professional engineer. They show the counties seeking and obtaining a court order to, quote, maintain the status quo, and their professional engineer signing off, saying that doing so will, quote, not introduce detrimental impacts to private property. I just do not see why or how plaintiffs can claim that the state somehow forced Wixom Lake to be higher in the spring of 2020 than it otherwise was going to be. I really do not know where they get that allegation from. No one asked to lower the lake in the spring of 2020. No one asked to raise it higher. The private owner brought the lake to its normal summer level in the spring of 2020, just had been done every summer for nearly 100 years before that time. Now, the best I can tell reading the plaintiff's briefing is that they've come up with 3 theories, none of which really make sense and none of which provide legal support for transforming their tort claim into a constitutional one. Their first theory, the plaintiffs seem to think that Eagle's dispute with the dam owner about the temporary winter drawdown levels of the lake had something to do with the lake's normal summer level. It doesn't. Most impoundments in Michigan have a normal summer level they're required to maintain during most of the year, but then they're allowed to perform a temporary winter drawdown during the winter months, usually between December and March, to help ensure that ice doesn't damage people's properties that are on the impoundment. That's what was in place for Wixom Lake. The normal temporary winter drawdown allowed the dam owner to lower Wixom Lake about 3 feet temporarily between about December and March each year. In 2019, the owners wanted to lower Wixom Lake temporarily, not just 3 feet, but about 8 feet during the winter. They submitted an application explaining they plan to return the lake to its normal summer level in the spring of 2020, but they just wanted to lower it more than usual in the winter. Their application is attached to State's Exhibit 23 on page 8, explains where they're going to raise the lake to its normal summer level in the spring of 2020. Well, Eagle denied the application, but then the owner did it anyway. So what if Eagle had said yes to the application? The owner would have done it. And in either circumstance, the owner would have lowered the level and then raised it to its normal spring level by about March of 2020. What Eagle did had no impact. It had nothing to do with the level of Wixom Lake in the spring of 2020. It is completely unrelated. Plaintiff's theory just does not make sense. So the second theory that as far as I can tell, the plaintiffs have come up with is that they try to argue that because Eagle did not object to the circuit court lake level proceedings, that was an affirmative act directly aimed at plaintiff's property. Well, not objecting is not an affirmative act. It's a precise type of non-action that cannot support an inverse condemnation claim. And the circuit court's decision belonged to the circuit court, not to Eagle. The counties held multiple public meetings. They fielded thousands, literally thousands of questions from the public. They hosted a Facebook page. They had an informational phone number. And then the court conducted a full public court hearing. No one objected to
May I ask?
Yes, Your Honor.
Your colleagues claim that you concealed the failure of the inability of the dam to meet spillway capacity.
No, Your Honor, that is not true. And our reply brief explains in detail why that really doesn't even make sense. Plaintiffs' Exhibits 1 and 2 are the FERC orders that revoked the dam owner's license. The entire basis for the Four Lakes Task Force coming into being and trying to take these dams over was to repair the dams. There was no secret knowledge. There was no information the public didn't have relative to the ability of these dams to function. That everyone knew that they needed to be repaired. Plaintiffs' Exhibits 13 explains in detail that that's the reason that the counties got together, sought a lake level order, and formed the Four Lakes Task Force to create a special assessment district to raise the funds to repair the dam. Everyone knew the dams need to be repaired. There was no concealment. It just doesn't make sense. And the state even granted $5 million to Midland County to help it jumpstart the repair effort. So really what we had was the private dam owner, Boyce Hydro, ignored FERC's requirement for nearly 20 years to repair the dam. And then FERC finally just revoked the license. And within months of the dam coming under state's jurisdiction, Eagle, the local governments, the local stakeholders had put together a plan to get the dam repaired. And that plan was underway. Really, the failure here is that the dam failed prior to the point when it could be fully repaired. But the real issue here, though, is that despite the need for the dam to be repaired, there was no one saying, including the professional engineer hired by the counties, that maintaining the normal summer lake level was somehow unsafe and couldn't be done. The counties repeatedly, their professional engineer repeatedly recommended to go ahead and do that. The owner of the dam also had a professional engineer. He raised no concerns about maintaining the normal summer lake level of Wixom Lake. Eagle didn't have any grounds to object to that proceeding. And even if it did, the circuit court very well could have overruled it. It was the circuit court's decision, not Eagle's decision. The plaintiffs just cannot demonstrate that failing to object in a circuit court proceeding somehow translates into an inverse condemnation claim. Now, the final theory that the plaintiffs have come up with, as far as I can tell, is that when the private owner in the spring of 2020 went to raise the lake level back to its normal summer lake level that had been in place for nearly a century, they submitted a permit application to Eagle, and Eagle did not deny the permit. They granted the permit, but no one suggested they should deny the permit. It was the private owner asking for it. He didn't object. The application was prepared and submitted by the county's professional engineer. No one raised concerns about granting this permit application related to the ability of the dam to handle a normal level, a normal summer lake level, not even close. So simply granting a permit application, aside from all of that, simply granting a permit application is precisely the type of ordinary governmental action that cannot form the basis for an inverse condemnation claim. That's well settled in Michigan law. Really, plaintiffs, they just don't have a way to transform their tort case into a constitutional one. The information demonstrating that impossibility is not secret. It's all public information that the plaintiffs' attorneys just did not look at before they went ahead and filed these lawsuits, which never should have been filed to begin with. The plaintiffs failed to identify any case where a court has allowed a takings claim against the government because a private dam failed, and their own exhibits contradict the accusations that they make and the story that they tell in their briefs. So plaintiffs' entire theory instead really what they've done is hinged their entire case on the Flint water crisis, which is strange to me. Plaintiffs argue that the failure of the Edenville Dam is just like the Flint water crisis. It is not. They might as well compare this case to that case where the government accidentally demolished the wrong building. It is just not comparable at all. So in Flint, the water system was owned by the government. It was under the control of a state-appointed emergency manager who apparently ordered that corrosive water that he had reason to believe would damage property be pumped into people's homes using that government infrastructure. Here, the Edenville Dam is not government owned. It was not under the control of the state or a state-appointed emergency manager. The state did not order that the dam be breached or take.
How do you draw the distinction between, you've acknowledged that the state took, quote, jurisdiction. What does jurisdiction mean if it is not some indicia of control? I know it's not an indicia of ownership, but is it an indicia of control?
No, it is not. Excuse me. Jurisdiction in this case is that when a dam generates hydropower, the state does not have jurisdiction to regulate its safety. The federal government does. So when the federal government revoked the private owner's hydroelectric license, jurisdiction over the dam safety passed to the Michigan Department of Environment, Great Lakes, and Energy. That happened in late 2008.
And that regulatory authority, from your perception of the law, is in no way an indicia of any control. You merely have the ability to suggest.
The state has the ability to regulate the same way it does the hundreds, if not thousands, of other dams in Michigan. And so, for example, to demonstrate the lack of control that the state has in ordinary circumstances, I attached the warrants that the state had to obtain after the dam failed in order to go in and do an investigation, because it's a private dam. And just being the regulator doesn't mean that the state controls it, can force the private owner to do things. The private owner wasn't willing to fully cooperate. So the state had to go get a warrant in order to give it permission to go on the land and inspect it, and had to get a warrant to do other engineering
So
analysis.
the extent of your power is to promulgate regulations, enforce regulations through the courts.
Yes. Just it's ordinary regulatory authority, the same way that, work safety agencies have the authority.
And is there any theory under which a failure to enforce existent regulations is actionable?
Not under inverse condemnation. That's well settled, and we've briefed it for the court, where multiple courts have explicitly held that the failure to regulate, the failure to supervise, even the failure to abate a nuisance are not actionable inverse condemnation claims. Those are potentially negligence claims, tort claims, but those are the types of claims that the state is immune to. So in order for an inverse condemnation claim to be actionable, the state has to actually do an affirmative act directly aimed at someone's property that substantively causes the property damage. So
All right, you said, go back, please. The state has to actually do an affirmative act directly aimed at a person's property that substantively causes it damage. So the examples we provide in the briefing are when the state builds a pier, or when the state builds a road, obviously, or when the state digs a hole on someone's land, Or I mentioned earlier, the state destroyed, or excuse me, I keep saying the state, but it can just be the government. Or when the government digs a hole in someone's land, the city of Detroit destroyed the wrong building at one point. So that's a project undertaken by the government directly aimed at someone's property. Because the Department of Environment, Great Lakes and Energy, for example, I'm not exaggerating, it issues over 10,000 permits a year. And that's just one division within the department. Those permit actions, it's just the everyday governmental regulatory undertaking of state government. And the courts have held that that sort of thing cannot form the basis of an inverse condemnation claim. There has to be some direct project undertaken by the government. And really the fact that the plaintiffs don't even bother citing the case law, the constitutional case law surrounding dam failures, shows that they know that they're embarking in unprecedented territory here. They're trying to pin an inverse condemnation claim on the regulator for the failure of private property. And it just is, it doesn't exist under Michigan law.
Okay. Is there another issue you want to attack, or do you want to wait until after you've heard from both of the respondents and tell me why they're absolutely wrong? Again,
I would prefer to wait for both of the respondents to go and then reserve the rest of my time for rebuttal. Thank you.
okay, thank you. Who is proceeding first?
I will, please, Judge, if I could. Morning again, Judge. Ven Johnson on behalf of the Mass folks. Judge, I know it's not lost to this court that that the state decided to bring this motion under C7, which is improper because all of the claims that have been brought so far, other than inverse condemnation, have been voluntarily dismissed by all Mass plaintiffs. And thus this court, the Michigan Supreme Court back in 1965 in the Thom decision at page 628, I think said it best. While the citizen's possession is subject to the power of eminent domain, it would be absurd and contrary to the explicit guarantee of the Constitution to say that if the state takes property without giving the required compensation, it therefore becomes immune from any suit to obtain that compensation. And therefore, governmental immunity, C7, does not apply to this motion whatsoever, since there are no tort theories being propounded at this point. So at this point, we believe for that reason and that reason alone, this motion should be denied. Then we get into the, I guess, discussion. And although we have recommended and argued in our brief that the court view this as a C8 motion, I would want to say a C7. We believe it's obvious why the state is bending over backwards to make that argument, because they would love to have an automatic right of appeal in the event that the court denies this motion. We obviously think such an appeal would be completely frivolous because this is not a tort action and we've not called it a tort action. So we believe that the motion should be denied. The court has the obviously discretion to call it a C8 or say this is not a C8, it's C7 and denied, and we go on from there. But I would like to argue on the C8 portion, if you will, if the court wouldn't mind me doing that. Under C8, of course, 2.116 C8, a failure to state a claim. Very interesting here in an inverse combination case that obviously the defendant is, if you will, stuck with assuming that the facts that we state in our complaints are true and that otherwise any type of an amendment would be otherwise futile. And when we look at the Constitution and we look at Section 2 of eminent domain, what we see in the third paragraph, Judge, is in a condemnation action, the burden of proof is on the condemning authority to demonstrate by a preponderance of the evidence that the taking of a private property is for a public use unless, and the exception to that, the unless part does not apply here since this is not an eradication of blight situation. So by bringing this action, we've labeled it inverse combination. It is inverse combination. Interesting that we believe the state has failed to acknowledge that the burden of proof is on them by a preponderance of the evidence, ultimately in this case. And thus, again, we look at the allegations that we've made. And when you look at Michigan being a pleading state, Judge, I remember having similar arguments with the court way back when in the trial court in Wayne County. Michigan is a notice pleading state, but the complaints in this particular case have been overwhelmingly fact-driven and absolutely make it crystal clear. Not only did the state absolutely know about this particular multiple violations of safety by these owners while it was still under FERC jurisdiction, but the state was actively involved, Your Honor, and our complaints absolutely set those forward. In particular, what I think are the highlights and the most important part is, according to the evidence that we've obviously cited, we've alleged our complaints and included in our brief, that FERC absolutely has indicated since the failure that prior to the revocation of the license of the void entities, back in approximately the date that we have is February 15 of 2018, FERC directly communicated with MDEQ, specifically reviewing with MDEQ the ongoing, what they believed, FERC believed to be the intentional violations of FERC's orders and requests to bring the spillways. And let's talk about what we're talking about. I didn't hear spillways anywhere in the state's arguments. The obvious violation was the inadequate spillways for these dams to have in the event of a flood situation. The spillways were inadequate under federal law, and we have asserted in our complaints overwhelming evidence that the state knew that the spillways likewise did not meet the state requirements either. And the FERC evidence that we've set forth in our complaints, Judge, in our brief, specifically discuss how, again, that there were ongoing violations of this spillway and that the state of Michigan knew that the spillways were inadequate as a matter of law under federal law. And obviously, and we're not in a discovery situation yet, which we think we obviously should be allowed to further go into this. But if it doesn't meet the federal standard, although there is a different standard under Michigan as well, we now know that the state of Michigan, by way of its EGLE director, Ms. Seidel, S-E-I-D-E-L, has in public documents that council loves to talk about. So let's talk about the public documents that exist that show her and EGLE's direct knowledge. Director Seidel has now admitted that in the early part of 2018, before the revocation of FERC's license, the state was aware of those ongoing spillway inadequacies and what the FERC was suggesting to be the knowing and willful refusal of the Boyce entities to, by way of what they called an outright disregard of their obligations and safety. And the state knew about that and did absolutely nothing when it took over the jurisdiction. And yes,
okay, Mr. Johnson.
Yes, Judge.
Mr. Johnson, I'm going to assume that every fact that you've said is true. Give me an understanding of legally why knowledge of misfeasance, failure to follow orders, or even malfeasance constitutes a basis for a takings claim.
Okay. And the answer we believe to be, Your Honor, the direct controlling authority of that lies within Mays. And we know that the state made the identical argument in Mays that they're making here today, that did not rise to the level of inverse combination. And we know that the Michigan Supreme Court, but especially in Justice Bernstein's lead opinion, absolutely ruled in every single one of the three elements that the complaints, if you will, that the C8 motion, if you will, was denied. The plaintiff did set forth similar, I'll call it, elemental prima facie evidence like we believe we've done here. first and foremost, to answer the court question directly, when the court looks at Part 315 of dam safety under the Natural Resources Environmental Protection Act, to call that simply regulatory and to suggest that extensive statute and regulations, I should say, don't give the state anything more than just regulatory authority, eliminates almost, in my opinion, half the provisions where if it's determined to be a matter of public safety, Judge, just like in Mays, and that was known about by the state, just like in Mays before the switch of the water went from Detroit to Flint. So the analogy there, they knew that, just like here, they knew that the voice entities were doing absolutely nothing to address the safety of the spillways. And therefore, they knew that the spillways absolutely did not meet their definitions. Under the Part 315 of the dam safety, Judge, the state had the obligation, we believe, to step in and assert what they must do by way of emergency orders, and without reading the entire statute to the court, I'm going to take over, if you will, and require that the voice entities do this, or otherwise assert control, which they could do under the Part 315 when a particular dam owner, by definition, abandons the property, abandons a dam.
So in essence, you're saying that their failure to act constitutes a taking, and you believe that, as opposed to in Flint, where in point of fact they acted and approved. So I want you to focus my attention a little more closely on that. Let me understand why Part 315 is so powerful that it almost becomes like willful disregard, something at that high a level, so as to constitute inaction to actionable taking.
Your Honor. Judge Stevens, I apologize, but I have nothing but massive feedback, and I don't hear.
Okay. I'll try again. I want to understand how, in this instance, the portions of Part 315 will translate a failure to act into a circumstance where, almost like a willful disregard, it is in fact an affirmative taking of property. I understand that Flint was a circumstance in which it is alleged that a state actor who had day-to-day control made a decision, regardless of knowledge that that decision was more likely than not to result in harm. In this case, the decision of the state actor would be the decision not to pursue remedies under 315.
I apologize to the court. I can't hear.
Okay, I don't know what to do about that.
I'm so sorry.
Okay.
Mr. Johnson, you might want to try leaving and coming back in to reset if there's a possible connection issue.
Would you mind, Mr. Johnson, if what we did is allowed your colleague, Mr. Dubin, to make his argument, let you come back, and I'll even let you start all over so you don't lose your place and your momentum, to see if you could hear the court's questions. I don't know if you heard that either. Probably not. Have you heard, did you hear? And we don't even have a chat. I don't know what to do about this.
Your Honor, why don't I text Counsel Johnson and have him try to reconnect?
Okay, thank you.
I just did that, Butch.
Oh, great. Thank you. Council
Technology is
Dubin.
wonderful until it isn't. Okay. Mr. Dubin, if you would proceed, we'll come back to Mr. Johnson, hopefully with a better connection.
Thank you, Your Honor. I guess I'm a little perplexed why today all I've heard from the state and from the state's motion and the reply brief is a focus on the underlying merits of the case. They filed their motion under C7, which is immunity granted by law. Mr. Johnson's already eloquently stated that the takings clause has been found by the Michigan Supreme Court to be outside the scope of governmental immunity. We have the takings clause, we have immunity. They're not coming together. In Michigan, the GTLA, the Government Tort Liability Act, is our North Star of immunity. The Michigan Court of Appeals has already stated, has already found that the issue of immunity, that the issue of the takings clause is not a tort under the GTLA. It is outside the scope of that. Thus, using the plain language rule, that GTLA, the Government Tort Liability Act, is not applicable here. And therefore, so is the C7. If we assume, as the state does, and using Mack versus Detroit.
Here, it's completely. Can you guys hear me?
We can. Could you hear your colleague speaking? Mr. Johnson? Okay, Mr. Johnson, perhaps please send him a note and suggest that when he come back in on a phone. We'll be able to hear him. Hopefully he will be able to hear us as well.
I'll do that right now, Judge.
Okay. Yes, Mr. Dubin.
Okay. I love technology. But as I was saying, if we assume the takings violations are governed by the GTLA, then we must assume there must be a statutory exception to the takings clause. Because if you look at MCL 691-1407, it states, except as otherwise provided in this act, and I'll paraphrase at this point, this governments are immune to tort liability. In Mack v. Detroit, it says a government agency is immune unless the legislator has pulled back the veil of immunity and allowed suit by citizens against government. Thus, the only way that we would ever have a takings claim is if again, assuming what the state is correct here, and that the GTLA is applicable here, is that there should be an exception to the takings clause within the GTLA. There's not. There's 6 exceptions. There's in other words, as a result, there would be no Mays, there would be no Tom, there's no electroplate, there's no Wiggins, because the GTLA covers it. That's the only way C7 is going to be applicable in this matter. Fortunately for all of us, we know that's not true. The Michigan Supreme Court has said that there is no immunity as it relates to the takings clause. Mays, and the reason why is that it's fundamental that the rights guaranteed under the Constitution are supreme throughout the state. Those substantive rights cannot be infringed on by legislative enactments. In this state, the only immunity that exists is found within the 1963 GTLA. There is no more common law immunity. The state doesn't disagree with this. What they do try to do is cobbling together C8, C10 standards to create this hybrid that is not supported by any case law out there. All the cases they cite are C8, C10. They do not have any authority to form the basis of support that in order for plaintiffs to get around immunity is that they have to satisfy the elements of unconstitutional taking. that doesn't pass the smell test. That's a C8 argument. And while I have no problem arguing C8, the better course of action would be for the state to file their motion for C8, not under C7. If therefore, we would have a clean record on appeal. You know, that's the reason why we had filed this motion, a motion seeking clarification from the court, and is that if you want a C8 argument, then file your C8. Don't try creating a whole new analysis for the takings, for the takings clause.
Now, counsel, there's a kind of consistent rule that says that the parties can call it whatever they want. You can call a tort a duck. You can call a constitutional claim a pig. But at the end of the day, under whatever rule you bring it under, I'm going to have to make a determination of what it actually is. So the clarification I appreciate, but I was obliged to accept the motion as what it says it is and to analyze it as what, in point of fact, under the law, I find it to be. And I do understand that when a thing is filed as a C7, there is an automatic right of appeal, and that might be considered a creative and strategic use of court rules. But as a practical matter, even if this was a C8 motion and I denied it, I will earnestly tell you that I would grant a stay. And even if I didn't, I'd be overruled by my other 24 colleagues, and they would grant the stay, and the appeal would go forward. That's just how it goes when we talk about a complaint that is of the magnitude of this. So let's talk about whether or not under C7, it is possible and appropriate for a party to say, well, you did plead in avoidance of governmental immunity because it is something to which governmental immunity does not apply. But in this circumstance, we know that you cannot meet the elements of the claim as you have pled it. Tell me why that's inappropriate and what it is that our appellate courts have cautioned me to do in such a circumstance.
Well, Your Honor, I would go back to if it's the smell test that you had articulated. This motion is a C8 motion. It isn't all, but by the fact that they haven't called it a C8, it is a C8 motion. And I agree with you that this case has significant implications for the citizens of the state and the state of Michigan. And I think it deserves to be treated like that. And given an opportunity for Your Honor, the Court of Appeals, and most likely the Michigan Supreme Court to have a clean record to make this important policy and legal analysis that are going to be necessary in this case.
But the question I asked you was a little different.
Yeah.
And my question was, is there legal guidance that says that when a party brings a C7 motion on the basis that while what is pled is purported to be in avoidance of governmental immunity, the elements of that claim cannot be proven? What am I cautioned to do in such a circumstance?
Your Honor, unfortunately, I don't have a direct answer to your question.
Okay, I'll just cut to the chase. If this is asking me to look at the underlying facts, and there are two different sets of facts being presented. One in your tree that you killed, another in their tree that they killed. Is this neither C7 nor C8, but really C10?
I agree with you. At that point, this is more of a C10.
It was a question.
Right.
It wasn't. I was not making a statement. I'm asking you a question.
No, I agree that this becomes a genuine issue of material fact. What I'm hearing from Mr. Johnson and Mr. Gamble, and for reading all the briefs, we have a conflict in the interpretation of the facts. The issue of inverse condemnation, frankly,
Actually, I don't, you know, what's interesting is the essential facts, I don't think you disagreed about. If I read correctly, we all agree that there was a private owner who has title to this dam. You agree that the owner was perceived to be out of compliance with FERC. You agree that the owner lost any licenses under FERC. You agree that the state of Michigan took jurisdiction as of some date in 2018 that you all know by heart, but I'm afraid I don't remember. You agree that the state of Michigan's jurisdiction is governed by a series of regulations and of very few statutes. You agree that the state did not pursue the most extreme and aggressive action relative to the dam under 350, Part 315, or prior to the dam's eruption. The fact that I saw that you disagreed about was whether or not they concealed the spillway issue or merely didn't address it. And I don't know how you hide that, by the way. And whether or not they were a party directly in whatever action took place in the county court. But you don't seem to disagree substantially as to the condition of the structure itself, the timing of the actions on the parties. I think that you have a substantial legal disagreement as to what constitutes state action for the purposes of takings, and whether or not, in the light most favorable to the plaintiffs, the actions that are alleged would constitute appropriate state action for a taking claim. I started walking through all of that paper, and other than the fact that it did make me very happy that I did not become an environmental engineer, it seemed that you both agree the dam was a mess. That's a scientific term. And that the dam got to be more of a mess, and then it erupted and caused substantial harm to the property of many independent homeowners who didn't do anything. You seem to align with that. But there seems to be a big difference about what you think constitutes a taking. And I'm curious as to whether you believe there is clear guidance that says, you know, in a circumstance like that, where there's substantial agreement on at least essential facts, that the court can't go beyond what it routinely does in a C8 and say that this is a claim that either can be proven, potentially under certain sources, once discovery moves forward, or cannot. What would you tell me?
Well, Your Honor, there's a number of things. First, I would look at Mays. And while I was not personally involved, like some of the people in this Zoom call today, to understand fully the underlying facts, what I have is the Mays Supreme Court, which does outline the standard that we are utilizing in this case, which is where the court stated as to the affirmative acts that the defendants authorized the city defendants to use the Flint River as an interim water source, while both sets of defendants knew that using the river could result in harm to the property.
And that's an authorization. This is a failure to withhold authorization.
Well, I would say, I would disagree with that characterization. Okay. I would say that they did authorize. You know, while there is some issue over this issue of everyone knowing. because there has been prior pleadings where the state has said they didn't know. Well, we'll hold that off for now. But assuming that everyone knew of the danger, they didn't tell the circuit court that when they, under the Part 307.
Were they a party?
They were a participant in that. They were consulted by the county defendants. They signed off on the order, the Part 307 order, and they signed the order. They were present at that hearing and never told the court of these extreme dangers with this dam. If everyone knew it, they didn't tell the court that. They signed off. So you believe that
your contention is they had a duty to disclose?
Well, once you know of the danger, I would say you have a duty to disclose. You know, everyone knew of the.
Okay, their duty to disclose arises from what?
Their knowledge of the regulatory aspect of their control over the dam, and their knowledge of how this was a major danger to the residents.
Okay, but generally speaking, there is no duty to disclose. So the duty to disclose is created by some special circumstances. Are you saying they're akin to a fiduciary?
No, I'm saying that as a judicial officer, and I'm withholding very important facts to the court and misleading the court to believe that a dam is safe when it is not. I think as a judicial officer, I would have an obligation. You're going to have to tell me.
Okay, that's a duty I owe as a lawyer, and I can certainly be disbarred. But the state of Michigan's not a lawyer.
Understood.
So we got to. I perceive the analogy, but I'm trying to understand. Is there something in Part 315 that gives them their duty? Is there something, again, akin to a fiduciary relationship? I need to understand. Did they make an affirmative? Did they make a statement that was materially false in the course of this? And are you alleging that they made a statement that was materially false that we just don't know about yet through discovery? I don't know.
Well, I go back to Mays here, and we have to look at the totality of their action in order to establish the affirmative acts. And while, yes, the circuit court sitting there silently on their hands and not informing of the dangers that they now admit they knew and gave the impression that it was safe, that these historic water levels were okay, I think it's part of the totality of the affirmative acts that they knew of, despite knowing, they didn't disclose it to the court. They allowed the court to walk away with a misrepresentation of the condition of the dam. They then turned around and utilized that court order to enforce dangerous water levels behind the dam. They continued to use that as a basis to force the water levels high. You know, everyone knew the water levels were high, knew the dangers, but the state then denied the efforts to lower the dam waters to address some of the deficiencies in the winter. Everyone knew that the dam was dangerous, but then they authorized the raising of the water in the summer. And then everyone knew it. Mr. Gamble then, sorry, go ahead, Your Honor.
I just want to understand the everyone knew. It's a nice hook, but I want to understand, are you saying that everyone knew, or are you in some way being facetious? I don't know.
I'm being a little facetious, Your Honor. I'm saying that I'm using what Mr. Gamble has now claimed, admitted to the state knew. I meant everyone as the state, not the residents, not the circuit court. They didn't know. The residents didn't know. If they knew, they certainly would have raised up their arms and been upset that their lives and their property is being put at jeopardy.
So the linchpin of this is some duty to disclose.
Some duty to disclose, yes. And then also some duty, I'm sorry, go ahead. I apologize.
No, I'm good.
Okay, all right.
Please.
I'm sorry. And then then they threatened them with litigation. There was an email from Mr. Gamble saying that we're going to sue you for over we want over $1 million in fines to protect these freshwater mussels.
You're going to sue whom? Of whom are you speaking now?
The state was threatening to sue Boyce, they eventually did, over the protection of freshwater mussels, and we're using that to force Boyce to keep the waters at unsafe levels.
Okay, so now that's actually an affirmative act. So you're saying that the state, by virtue, in some ways, the state, by virtue of threatening to sue, coerced Boyce into keeping the levels high, despite knowledge of spillways?
They utilized the court order, circuit court order, and then utilized this pretext of mussels, freshwater mussels, that the lives of freshwater mussels were elevated above the property rights and lives of humans. And we're threatening that if he lowered the water, that would jeopardize the lives of these mussels, that he would be fined, and that fine should be 7 figures. I guess I look at the analogy as I'm driving my car at 55, it's wintertime, I come across black ice, we all know to slow down. In that context, the state is sitting as my passenger and is pushing my foot down onto the gas pedal to keep me from slowing down, with a gun to my head, with a threat that I'm going to end up basically killing the corporation with $1 million fine. What is Boyce?
Interesting theory.
What is Boyce then to do? Boyce loses the free will. Essentially now the state is in the driver's seat. They've taken over, knowing that it was dangerous up ahead.
And if I go through your pleadings and the facts that are pled, I'm going to see this particular set of facts, that the threat constituted, that the communication that they would sue if water levels were lowered was an affirmative act. I will see that somewhere in the papers.
That's correct, Your Honor.
Okay.
And they also used that circuit court order to—
I know you keep going to the order.
I know, sorry.
That's not your best shot here.
Okay, all right.
Okay. Your argument, unless you feel compelled to tell me more, I will let Mr. Johnson resume.
Well, I will yield to Mr. Johnson. I trust in his abilities here.
Well, after I just got zoomed, Judge, maybe no one should, so I want to apologize to the court for that. But what the court, I believe, was asking me about, and is now talking with Mr. Dubin, is about the affirmative acts. And we have pled multiple affirmative acts, which include, Your Honor, in October of 2018, this is after FERC has now revoked the license, which I believe took effect on September 25 of 2018. Not that the court wants that date, but that we were talking about it. So here we are just a few weeks later when MDEQ report from Mr. Pawlowski, and this is in our complaints, I believe to be PAWLOSKI, he issues a report where, despite knowing that FERC was revoking the license due to the inadequate spillways and the danger that they posed to all residents, and I might just not for purpose of property, but the repeated statements about property and potential personal injury to these people who live on these properties. Mr. Pawlowski then, in his report, if you will, calls the dam that it was now in fair condition, end quote, and allowed the continued operation despite, and that the dam showed signs of moderate deterioration, knowing full well that when he's doing that by Eagles or MDEQ's own standards, that the dams did not meet the spillway specifications under Michigan law. And yet he still absolutely did that report. Now, not only do I call that affirmative report, the court asked questions of counsel about concealment. And in my opinion, that's certainly one particular piece of evidence of both. Then we have, Judge, in 2019 timeframe, where again, thanks to the emails from the Eagle director that I cited to the court before, Ms. Seidel, we now know that by long before the fall of 2019, Eagle now, or MDEQ, formerly MDEQ, knew that the spillway definition was not met by these dams, and therefore these dams were an absolute known hazard. And again, I keep going to known hazard because that therein is the 100% perfect analogy to Mays. It wasn't just that they switched water. They switched water knowing what the switching water would entail in terms of the adverse effects on the water and potentially the health of people in Flint who would drink the water or use the water, and the damage that it would cause to the pipes. Same thing here. MDEQ, Eagle, knew that by allowing this dam to continue to operate, now that the feds have revoked that license, they did it because of safety concerns about the spillway and the hazards to people. So that is absolutely what we believe to be an affirmative action, if you will, and a choice, knowing full well that doing so risks the danger to people and property. And then,
Mr. Johnson,
yes,
Mr.
Judge.
Johnson, doesn't that bear a terrible resemblance to reckless disregard and gross negligence?
Well, the answer is it certainly could, yes. And that's why if the court believes, and one of the things under a C8, which again, if I'm arguing that, I don't think it's a C8. To answer the court's question about C10, yes, this is a veiled C10 with all these facts and so forth, and it shouldn't be, and therefore should be denied accordingly. But if it's brought under a C10, we still think, and I simply point out to the court, in Mays, Judge, they didn't bring that motion under C7. In Mays, the Supreme Court opinion that we have in July of 2020 was brought under C8. So that's an interesting point. And then under C8, we have simply, in Justice Bernstein's opinion at page 10, that plaintiffs alleging that the switching of the water source to the Flint River resulted in the damage to the pipes and ultimately people and substantially impaired value. Judge Bernstein's opinion, which I believe everyone's or most signed on to relative to that finding in the denial of them, or in other words, affirming the denial of C8, he said that that was sufficient under a C8 analysis, which is exactly what we have here. So what we believe, we also have the affirmative act, and yes, we do disagree with the state, that the water levels, Judge, my understanding of the facts are that Boyce was vehemently against increasing water levels. In fact, my understanding, and I believe this is in our complaint, I know it's in our brief as well, that Boyce allegedly, without authorization, decreased the level of the water, and the state then, in part, sued them, and therefore increased the levels of the water because they were concerned about the environmental hazards. Yet again, another affirmative act by the state, knowing full well that by increasing the water levels, increased the risk of dam failure because they knew that the spillways were inadequate. Therefore, potential hazards to human life and property. Affirmative acts. And again, just like we believe in Mays, under the C8 analysis, we believe that we have gone well beyond notice pleading. If the court doesn't think we have, we would certainly appreciate the court's a willingness to allow us to amend, because we believe under these facts, we can and have, if you will, stated a claim under which relief could be granted on inverse condemnation. And again, I apologize for being Zoomed and appreciate everyone's patience.
You know, apologize for the things you can control. You don't control the internet. I know you're powerful, but not quite that.
Thank you, Judge.
Counsel, on behalf of the state of Michigan and its many units, what would you wish to say?
Thank you, Your Honor. First, it is remarkable to me the extent to which the plaintiffs are trying to persuade the court to look away
from public court filings. That's really what this dispute about C7 or C8 is about. They don't want the court to see that public court filings contradict the story that they have come up with. They want the court to just assume that their story is true and not contradicted by public court filings. Really, the court should look at those public court filings to see that they do not support what they are telling the court. For example, Plaintiffs Exhibit 13 is the lake level order prepared by the county's engineer.
And
It
you
was
have pointed
filed-
out, you have pointed me to 7 different sections of section 13. Okay, Exhibit 13 and several different pages. I'm sorry.
I have, Your Honor, and it's because simply reading Exhibit 13 contradicts so much of what the plaintiffs are alleging happened here. For example, they keep saying that the public was unaware that the dam needed to be repaired. That is such a strange thing to say to me, because the entire reason for creating a special assessment district was to raise the funds to repair the dam. So I'd refer the court to page 12 and page 13 of Plaintiffs Exhibit 13, where the county's engineer explains that the scope of the project is to repair, maintain, and operate the infrastructure that already exists and has been in operation for nearly 100 years. And then it establishes an implementation schedule to operate normal lake levels in 2019, and then as soon as possible to implement necessary repairs and improvements on all 4 dams by 2023. The 4 Lakes Task Force will be required to implement repairs and improvements to Edenville Dam, and then it lays out an implementation timeline, tentative schedule by which they will complete repairs, beginning with the circuit court hearing in May 2019, not all the way through 2023. There's a construction schedule to do these repairs. So I just don't understand why the plaintiffs are fixated on this idea that the public was not aware that the dams needed to be repaired. They are the ones who are going to have to pay for it. The thousands of people who belong to the special assessment district, the reason they were going to receive bills in the mail was to raise the funds to repair the dams and to maintain and operate them. The reason the state gave $5 million to Midland County was to jumpstart this process. To put this in context, the last time that Eagle tried to force a private dam owner to remove or repair a private dam, it was the Grass Lake case, and there's a lot of case law if anyone's interested in researching it. It took 10 years, and that's with the state paying for it. That's because when Eagle just orders someone to do something, they can say no and file a lawsuit, which is what generally happens when you have a private dam owner that doesn't want to cooperate. In this situation, within months of the time that the state had regulatory jurisdiction over the safety of the Edenville Dam, a plan was in place. A construction schedule was established. A funding source was identified to go through and repair these dams. An important thing to understand about this dam is that it holds back 40 feet of water. And the lowest that the dam gates can lower is about 6 to 8 feet. So when you lower a 40-foot body of water 6 to 8 feet, it doesn't do much. That's, as we explained in our briefing, Your Honor, why in 2013, when the Federal Energy Regulatory Commission was curious about whether, because of the danger posed by the inadequate spillway capacity, whether FERC should require Boyce to lower the dam, lower the lake level a few feet, Boyce said no. It really wouldn't do anything. They had an engineer do a study. FERC agreed and said, yeah, I mean, it would delay the peak by about an hour. And so really the only solution here is to repair the dam. If Eagle issued an order to do.
And counsel, that very much goes to your argument that whatever the state did or did not do was not a substantial cause of harm.
Yeah, absolutely, Your Honor. That's
Okay.
absolutely the case. In fact, the state
But
was.
that definitely is a fact-intensive question, and you agree to that. You're either, I mean, that's pure fact.
Well,
And it's not a fact that relates to immunity. It is a fact, and to whether a thing is a taking. It is a fact that relates to whether or not, even if it is a taking, there is a harm that's compensable. So probably we want to get back to whether the state was an affirmative actor, and anything more you want me to understand about why in this instance they were not an affirmative actor, as opposed to whether or not they acted or not, would it have made a difference?
well, Your Honor, I will get back to that. And the only reason I was providing that explanation was to provide additional context, because the state's being accused of doing nothing, which is just silly. It's not true. And so, but to get back to the affirmative act, the main place where the plaintiffs are hanging their hat here is a lawsuit that the state filed in the spring of 2020 to recoup environmental damages caused by the unauthorized temporary winter drawdowns. When you draw a lake down 8 feet instead of 3 feet, it exposes a lot of lake bed, and that has significant environmental impacts. The lawsuit
and your motivation for filing it, I don't think that they seem to be making an assertion that regardless of your motivation, that the net effect of filing that was to encourage, for lack of anything else better, Boyce's misfeasance or malfeasance. And that therefore you are somehow taking control, as if you were, you're overwhelming his will or in some way coercing him. What would you say the law is on whether or not the state, by taking action which is authorized by statute, can be seen to be coercive and therefore exerting control?
Well, first, Your Honor, that lawsuit is attached as Exhibit 17 to the state's briefing. The court can just read it and see what its basis is, what the relief is that it asks for, to see that it does not seek to compel Boyce to raise the water levels. That's because the water levels were already controlled by a circuit court. And the lawsuit was filed after Boyce had already raised the water levels. It just doesn't make any sense to say that it was about trying to compel Boyce to raise the water levels. And simply filing a lawsuit.
Your assertion would be it is not a coercive act because what you thought had already occurred?
We didn't seek that. That's the point. The plaintiffs are making this muddy when it's not. A winter temporary drawdown is different than the normal operating levels on an impoundment.
Or normal operating levels what?
Normal operating levels on an impoundment. So, or a lake that's created by a dam. The private owner of the dam did a temporary winter drawdown for a few months that caused environmental damage. And then he raised it back to its normal spring levels without the state trying to force it. The circuit court already required it. And so the state sued later on to recover past environmental damages. The idea that the state is forcing him to do something that he doesn't want to do just doesn't make sense. It doesn't correlate with reality. And so that, we refer the court to the lawsuit itself. It's State Exhibit 17.
So
All right.
we weren't coercing him to, no one asked to lower or raise the normal level of Wixom Lake in the spring of 2020. No one tried to lower it or raise it or set it at a level different than the normal operating level it had always operated at. And
I think I understand your argument after about an hour and a half.
okay, I apologize, Your Honor. I'm not trying to beat a dead horse. I just, this is briefed out, I think, in some detail. We would refer the court to the
239 pages on one side. Yes, at least. It is brief.
It is. And so the other thing, I'd refer the court to, well, actually, you know what, Your Honor, I'll stop. I mean, I trust obviously that the court will read our briefs and it makes the points clearly.
Not will read. The court read your briefs.
I apologize. Yes.
Thank you.
So with that, Your Honor, I think that the point here is that if someone sues the state for property damages, the state's generally immune to that unless it's a constitutional claim. And they have not transformed their tort claims into a constitutional claim. They don't have a basis to do that. Publicly available information demonstrates that the story they're telling is not at all accurate. And so with that, Your Honor, we ask that the court dismiss all 11 of these lawsuits.
Thank you very much. The case will be submitted.
Thank you, Judge.
Thank you, Judge.
Thank you, Your Honor.
Excellent arguments and briefing. Thank you.
Thank you, Your Honor.
Does anybody want to order these? I will.
Yeah, yes, please.
Mr. Johnson, you want to order?
Yes, ma'am, please. Thank you so much.
All right, thank you.
The state would like.
Hello, the state?
She was saying the state wanted a copy too, I could tell. Sorry, Teresa.
Okay,
Thank you, ma'am. Have a great day.
you too, Mr. Johnson.
Thank you.